My name is Beth Morrison. I'm the president and CEO of Haven, which is Oakland County Center for the Prevention and Treatment of Domestic Violence and Sexual Assault. And I'm here opposing this bill. I'm also here as a support person for Dawn, and hadn't planned to testify. But I would like to make one comment before passing the microphone on to Dawn, and that's to a couple times there's been reference to domestic violence and somewhat downplaying incidents. Domestic violence and sexual assault are both two crimes that are much more prevalent than society seems to know or recognize. And in this particular bill, I think the issue is, I, like others have said, I'm all for joint custody when both parties can agree to it and when it's something that is in the best interest of the child. I think what we're talking about are the disputed cases, and in those disputed cases, more than likely there is going to be a high incidence of domestic violence in those disputed cases. So I just wanted to make note of that. And now I'd like to turn it over to Dawn Kraft. Dawn is going to tell her own story, but she is here to share her story, and we certainly support the right of the survivor to be able to speak up and hopefully make their situation become part of the knowledge base of others.
Yes, we welcome you. Don't be as nervous as Mrs. Taylor. You look mean, you don't bite. And thank you for the courage to be here.
Thank you for having me, and yes, I'm a little bit nervous, but I'll get through it. I just wanted to let you know, I've heard some talking today about how the current system, the best interest of the child, doesn't work. And I will tell you that in my case, that was the case. However, if this current bill had been the law at the time, it would have been more detrimental to my daughter than the current system that we have. I left my batterer in 2005, and immediately the my batterer requested file for joint custody. Right away, I let the court know that there was domestic violence. Not only domestic violence, but I have 3 children from my first marriage who were abused, and our own daughter was also abused. I was looked at by the friend of the court and the judge and said, well, now that you're out of the situation, this will never happen again. Best interest factors weren't even looked at. And I knew that wasn't the case when I was asked if I had any proof. And of course, there was proof of coming from me and the children, but nobody wanted to hear that because it was automatically, I was accused of being vindictive, that I was trying to alienate my ex-fiance, and that despite, even if there was abuse, that he was going to be a fit parent for our daughter. Within about 8 months, we ended up in the doctor's office with an injury to my daughter. She was picked up and thrown about 5 feet across the room. And what's interesting about that is that even after that, she was sent back. 6 weeks parenting classes that was all that was ordered. She was coming home from visits screaming and crying. She was begging me not to send her. She was telling me that I didn't love her because why did she have to go when her siblings didn't, not understanding that that was not their dad, their dad. And it took nearly 1.5 years for somebody to listen, with a new CPS worker and me insisting, please, to have communication between the friend of the court and the CPS worker to please have some communication and see. Because one party's saying it's your fault, the other party's saying it's your fault, but they kept sending her back and she was in danger. This current bill that's up, if it would have been the law at the time when we split up, I probably would have stayed in the situation longer. One of the reasons I didn't get out of my situation is because I had heard the horror stories of they're going to send her unsupervised, and at least when I was there, I could protect her. When I'm not there, I couldn't protect her. And that's exactly what happened. This current bill, if that would have been the case, she would have been sent there from day one, 50-50 split. And had that occurred, she would have been in far more danger than she already was, because she would have had more interaction with him on a regular basis. And I would have had to go in there and prove that he was unfit. And I, in the current system, already did try and prove that. And there wasn't a single person that would listen to me. There is a misconception in the current court system right now that if you go in and say domestic violence is occurring, that it's going to stop the minute the parties separate. Well, batterers don't stop battering. And batterers who abuse their partner, a lot of times, abuse children. So I oppose this bill and the fact that you're going to, if this bill were to come to a vote and it became law, we would be putting so many children in harm's way, and it would be up to the protective parent to try and convince somebody that already doesn't understand domestic violence that domestic violence is occurring and it's a bad situation. So I wanted to put that out there, and I thank you so much for your time, and I just really hope that you'll really think about this before you ever consider putting it to a vote.
Thank you.